All right, class. Welcome back to product liability. We've just discussed the elements of strict liability, and now we'd like to spend some time talking about the topic of proving a defective condition. Now, if you would like to, in advance, we're going to be talking shortly about case 5.6, and that is Riley versus Ford Motor Company. In relation to this, the Riley case illustrates the role of experts in the product liability substrate. But we should probably mention that there are, under any product liability theory, all right, whichever product liability theory you use, you have to establish a defective condition, right? You needn't always, for example, in strict liability, you don't have to prove how the product became defective, but there's always an element of having to establish that there is a defect because it's product liability. What are we holding them accountable for, right? For producing a defective product. So with intentional misrepresentation, right, this deceit produces the defect. I want to sort of remind us, a couple of sessions ago, I brought up a foliage cutter, like a weed whacker, right? And in the scenario, this weed whacker had a design that would enable someone using the product to to cut shrubs up to 5 feet in height, right? The packaging incorrectly stated, intentionally in this case, that that you could cut shrubs up to 10 feet in height, right? The instructions led plaintiff to the misuse that caused their injury, right? So in the case where the instructions led plaintiff to use the cutter in an unsafe way, right? If the instructions had been correct, plaintiff would have been misusing the product, and that would have been product misuse, and that would have barred them from recovering, right? But in this case, in the weed whacker case, we'll call it, the instructions were intentionally placed there, right? And so those instructions that indicated that the product could be used on a much larger piece of vegetation, the instructions are defective. If the instructions are defective, this essentially makes the product defective, right? So that's the intentional tort of negligence, right? Moving on to negligence, it's more complicated to show the defective condition. Why? Because what does the negligence relate to? It relates to a lack of care. And what does the injury related to? What is the injury related to? It's related to damage that's caused by a product. There has to be a connection between them, and that connection is essentially proving how the product became defective through defendant's carelessness. All of the people that I mentioned along that chain, right? Manufacturer, wholesaler, retailer, right? They must be individually liable as opposed to strictly liable, right, for their actual behavior. The plaintiff has to show a lack of care, right? Some action or failure to act on the part of the party that's being sued. There is the causation problem that I previously indicated when I discussed negligence, right? I mean, it's simply a part of negligence that you show this. Strict liability, however, doesn't require us to show how the product became defective. However, we have to show that the product was defective and unreasonably dangerous when sold by the defendant. All right. So in this Riley case, Riley versus Ford Motor Company, right? So Mr. Riley was a Ford was driving a Ford F-150 pickup, very popular model in South Carolina. It collided with another vehicle, right? The impact caused Riley's truck to leave the road and roll over. The driver's door of the truck opened in the collision, and Riley was ejected and killed, right? As a assume arguendo, this case again 5.2, Riley versus Ford Motor Company. The collision aside, the doors on these vehicles, on any vehicle of that type, any car, any truck with doors, right? The latches need to be designed to hold, to lock, and to stay locked under most circumstances, even in a collision. All right. So in this case, the next of kin, the wife, represented the estate, filed a product liability suit in South Carolina. The plaintiff alleged that the door latch system, the equipment that held the door shut once it was locked, was faulty. All right. The court awarded $900,000 in damages. And so Ford appeals, arguing that the plaintiff had not proved the existence of what's known as a reasonable alternative design. We're going to come back to that in a second, right? This utilizes what's known as a risk utility analysis. Now, before I don't want you to get too far ahead into those terms because I want to explain them. I want to just get into the test, right? Or to get into how they handle that. What a risk utility analysis does, in short, is that it looks at options, right, and sees if one, meaning some alternative, right, that would be proposed would have worked more efficiently, more safely, and relatively cost effectively as compared to another, right? That's called a risk utility analysis. And if it goes in the plaintiff's favor, then what they've established is that they have a reasonable alternative design that would have prevented the injury, right? So in Mr. Riley's case, we know that these doors are supposed to hold shut when they're being operated. So, in short, to satisfy the risk utility test, the party who would recover, the plaintiff, has to show the nature of a reasonable, feasible alternative design that would have prevented the injury. And this is the essence of the risk utility test. So Riley had this Ford F-150 pickup, and it had a rod linkage door latch system. The estate presented evidence of Ford's own reasonable alternative design. Now, you can imagine how complicated a piece of equipment it must be. I mean, obviously it's a lock, right? But it's inside of a complicated piece of electronic equipment. So they presented evidence of an alternative design that was in Ford's own files. It was a cable linkage door latch system, as opposed to rods, using cables to hold the door closed instead. And they used this system before occasionally before the year in which Riley bought his 1998 model that resulted in his death. So that was the estate's primary evidence, was evidence of this alternative door latch system. There were a couple of advantages to the door latch system, we'll note, all right? They required less packaging, they required less space, they were more robust to crash, quote, right? Just to have that phrase in there. For performance, the cable systems provide better performance to the customer. At manufacturing, cable systems are easier for the assembly plants to handle, right? So there's a lot of utility to this feasible alternative design. Now, the only disadvantage which was indicated in Ford's files that became salient in this trial was that the cable systems are from 2 to 3 times as expensive. 2 to 3 times as expensive as the rods. However, this resulted in an additional cost of about $9 per door, as opposed to $4.25 in the rod system per door, in the rod system that was actually in use in Mr. Riley's Ford. Now, right, if we were talking in terms of 2 to 3 times as expensive, that's one thing. But when we talk in terms of $4.25 versus $9 for Mr. Riley's life, you can maybe predict how this case is about to come out. A second form report noted that after 1993, cable systems provided improved quality, were easier to install, and were more robust to door foreshortening, meaning warps in a crash. Apparently, the only disadvantage was that the door cost, again, was 85 cents more per door. So that second study found an even smaller price differential between the feasible alternative design and the design included in the vehicle in which Mr. Riley's fatal accident occurred. So the South Carolina Intermediate Appellate Court, where this ended, affirmed the lower court's ruling. They said that the evidence showed that Ford knew of a reasonable alternative design for the rod linkage door latch system. Ford was aware of the system's safety problems and had conducted a risk utility analysis of a cable linkage system, concluding that it was feasible, if not a superior alternative. All right. So as you consider this Riley case, take a look at this Riley case, and then I'd like you to answer this question. It will appear in the prompt. By what means did the plaintiff likely discover defendant's studies of a reasonable alternative design? I'd like a little bit of detail. How might that? What might they have used in order to obtain that information? Thank you very much, and I will talk to you guys shortly. Take care.